Welcome to The Print. My name is Apurva Mandhani and I'm going to be your host for this month's ThePrintCharcha. This is 12th edition of our show, which is called ThePrintCharcha. In this episode, we're going to be talking about a deeply divisive issue of the death penalty. The topic, as we know, is hangman in the dock. Is India awarding too many death penalties? And for this discussion, we have with us a panel that has interacted with and even influenced the jurisprudence around the death penalty in their own ways. Let me introduce all of you to our panelists first. We have with us a former Supreme Court Judge, Justice MB Lokur. We have with us Senior Advocate Meenakshi Arora. And we have with us Dr. Anup Surendranath, who is a professor of law and the Executive Director of Project 39A at New Delhi, which does some fabulous work when it comes to death penalties. Thank you so much to all of you for joining us. Just to let you know, just to let our viewers know, this interaction is exclusively for our subscribers, with our subscribers. I have now let all our subscribers in and just want to take a minute here to thank all of our subscribers for joining in and for supporting us, because it is only because of the support of all of you, people like you, subscribers like you, that we continue with our unhyphenated journalism. Now, just to start with the webinar, I have a few questions of mine here, but we also have a few questions that our subscribers had already sent to us. They were really eager for this discussion. Just to start off with a few statistics here, which might also explain why we have we called this discussion "Hangman in the Dock: Is India awarding too many death penalties?" With 165 death sentences, this was the most in a single year since 2000. The year 2022, that is last year. So capital punishment actually exact a heavy toll in India. In fact, last year the number of prisoners on death row in India stood at 539, which is the highest in 17 years. So the first question that I'd like to put to all three of you, and you can answer it one after the other if you want, is how is the death penalty being awarded by the trial courts, and why have the numbers shot up? Is there a sudden shoot up or increase in these numbers?
Yeah, Anup, go ahead, please.
No, look, I think there's, for a while now, there's an exaggerated use of the death penalty in the trial courts. And the numbers always have indicated that. And if you, the kind of numbers we put out since 2000, the analysis that we've done of numbers since 2000 show that, the trial courts have this exaggerated use. About 40 to 45% of all, let's say, of every 100 death sentences that trial courts give, we're looking at 40 to 45% resulting in acquittals, ultimately through the high courts or the Supreme Court, and a further 50% being commuted. It's and there's a trend that's been happening for nearly 2 decades, and I think the big shift in the last few years is, I would say, that the kind of offenses which you're seeing the death sentence being given for, and from murder simpliciter, sort of if you were to understand where only murder is involved, you're now seeing death sentences being awarded for a much higher proportion where there is sexual violence and murder. And I think the popularity, if I may call it that, of the death penalty in India is riding on the back of the need for a strong response to sexual violence. But that's another issue to discuss, what does the death penalty mean for sexual violence in India. But I think it's very clear that what is now driving the death penalty in India is it's seen as a response to sexual violence. Yeah.
Dr. Surendranath, we will probably take that up, the pointer on sexual violence soon, because we have a question from one of our subscribers around that. But would any of the other panelists, would you guys like to add anything to what Dr. Surendranath just said?
If I can just come in, my feeling is that we are seeing a larger number of violent crimes, mob lynching, for example. That's involves a lot of violence on one particular person, maybe two particular persons. We are also seeing a different variety of crimes. Like, we've had this thing about some girl being chopped up into 100 pieces and, things like that. So there is this tendency towards violence, and sexual violence, of course, is one of them. So I think this is just a feeling that I have. I mean, there's nothing to support, no evidence to support this. But I think the imposition of a death penalty is a reaction to the violence that we are seeing in society. Okay, it could also be terrorist violence, that kind of stuff. So perhaps that is the reason why we are seeing more death penalties today or in the last couple of years than we have seen in the recent past.
Right.
I just have a very small comment, and that coming from Anu, that we've had much higher rate of death sentence where it's come to sexual violence. I remember when the discussion started on introducing death sentence on sexual violence or rape, etc., the general reaction was that as it is, you have a very low conviction rate on many of these offenses. And if you put a death sentence there together with it, the conviction rate will come down even lower. So this is a little bit of a surprise. And there I would just agree with Justice Madan Lokur that sometimes we do have a knee-jerk reaction on maybe the violent crimes because we want to show that we are doing something to curb, but that may not be necessarily always the right thing to do in terms of a death sentence. So the issue is where you should award a death sentence, whether the circumstances demand it or not, but not merely that every single crime of a sex abuse or, as you have said, mob lynching or everything would call for a death sentence. So I think there's somewhere that needs a debate and a discussion that, merely because there are higher rate of sexual crimes, you want to give a death sentence. That perhaps is a thing that we probably will discuss, I hope so, later.
Yeah, that would, I'm sure that would come up in the course of this discussion. For our subscribers who've already joined in, just a reminder, please don't hesitate to send in your questions or your comments. I would love to put them up to our panelists and they'd be happy to answer all your questions. One of the questions that I'd start taking questions from our subscribers, Aditya Chandra, who's a subscriber, he says that don't you think for crimes and offences which are related to terrorism, rape of women, which we've already mentioned in the course of this discussion, there should not be any option of mercy petition, considering the fact that we as a society have not been able to set a very strong precedent for such crime and offences, and we see every year that such events keep happening. Would any of you like to take this up?
Yeah, well, there are, of course, terrorist offenses in India, but there are terrorist offenses in other parts of the world as well, right? And in many of the countries, they do not impose a death penalty for terrorist offenses. First of all, there is no standard definition of terrorism. There is no standard definition of who's a terrorist. So somebody who may be classified as a terrorist in India may not be classified as a terrorist in some other country.
Right.
Okay. So when you talk about terrorist cases or terrorist offenses or terrorism, there's a problem of a definition. And a terrorist, whether you're going to give him death penalty or not give him death penalty, it's not going to deter him at all. The reason why he's into terrorism is because he wants to do it, and he doesn't care for his own life. So imposing a death penalty on a terrorist is not going to curb terrorism. And I think our experience in some of the other countries where terrorism exists, it doesn't seem to have made any difference. So really to say that, in terrorist offenses, you must give death penalty and no mercy, this, that, and the other, may not necessarily be the answer.
Right. Dr. Surendranath, ma'am, would you like to add anything to that?
Yes, I think that comes from Project 39A reports that the death sentences, or or the awarding of the sentence hasn't brought down any levels of crime or the offenses for that matter.
Mm.
So in the sense, if you say that a death sentence is a deterrent to bring down the rate of crime, that hasn't happened.
Right.
So I think that's again an issue that will be, I think Anu probably will have much more to add to that than any one of us, because that's Project 39A's, I think, research shows that.
Yeah. Thanks, ma'am. I think, just want to just separate the responses to terrorism and to sexual offenses and just come at both of those points. I take Justice Lokur's point on martyrdom, and I think we don't engage with the complexity of that sufficiently in terms of saying that is the death penalty a deterrent to terrorism? I don't think it is. If you look at countries like Israel or even when Britain did away with the death penalty legislatively, it was at the height of the violence in Northern Ireland that Britain does away with the death penalty. And look, the idea is that even if you look at what is happening in Israel, which by the way does not use the death penalty, but let's not project Israel as some sort of model penal state given how they respond to. But the point I'm trying to make is even in Israel, you see that the harsher and harsher treatment that they mete out is not going to be a deterrent in these contexts of terrorism, right? And that the solution lies elsewhere, right? And even if you look at the statistics that we have put out of where the death penalty is used, you will see that the death penalty is not used in India's, for lack of a better phrase, conflict zones, right? That the death sentences are not given for these kind of offenses against the state, right? And that there might be very good reason for that, because the state is using different responses to violence. It is using sort of extrajudicial responses to violence in these contexts, and really has no patience for the process of the death penalty to play out in that sense, right? In a sort of to go through that legal process. Mm-hmm. On sexual violence, I think what we need to understand that both for sexual violence against adult women and sexual violence against children, the offenders, statistically by the government's own data, that the offenders are people known to the victims or the survivors, right? So it's that the stranger rape is a bogey at the end of the day, right? And harsher punishments, again, in a very different sense from terrorism, is not going to bring down the vice of sexual violence in our society, right? And we seem to have this rather unchecked intuition that the harsher punishments you give, people will fear it and then will not commit crime. But that's not how crime is produced in society. That's not how people respond to crime. And we really need to question that very fundamental assumption we all seem to make, that harsher punishments leads to reduction in crime, right? That's not how it plays out. Yeah.
That was actually one of the questions. But since we've now discussed the death penalty being, the understanding being that it could function as a deterrent and why that might not be true. But we have a question coming in from our subscriber on me mentioning the higher rate of death penalty being awarded. And the subscriber's question is that, are we seeing a higher rate because we are processing more cases and probably have improved our conviction rate?
I think if at all anything the data is showing is that post the Nirbhaya amendments to the criminal code,
right.
Post the 2013 amendments, conviction rates have fallen, right? And I think there's data now from Delhi looking at sexual violence cases where the conviction rates are falling, right? So that's what, and it's something to think about. Why that more stricter, harsher laws, then what it has a counterintuitive effect on adjudication.
That's exactly
right?
what ma'am said, mentioned in her answer to the first question. Would either of you like to add anything to that?
Yeah, I agree with Anup. If you remember when the NDPS Act came into force, right?
Yeah.
minimum sentence was 10 years. Judges were very, wary about convicting a person because they knew that if something goes wrong, during the investigation or during the trial or something, and they overlook it, then that guy is going to be inside for 10 years. Right? So you had a lot of cases of NDPS where, persons got acquitted because the sentence was very harsh. All right, this is one example which has been there for a long time. So, yeah, the harsher the punishment, I think judges are, very much wary about, convicting the person.
Right.
You have preventive detention laws, where a person is inside without even having committed a crime, on a prognosis that the person might commit a crime. The law is procedural, but it is so strict, that a representation made by a person under preventive detention, if you delay the consideration of the representation by 1 day, 2 days, 3 days, it's good enough for the court to say that, listen, we set aside the order of detention. So making the law harsh, is results in a sort of a pushback from the judiciary.
And almost sounds counterintuitive. Ma'am, would you like to add anything to that?
Yes, from what we have seen, I would completely say what Justice Lokur is saying, because we must not forget the fact that two factors, in fact. First of all, when you want to impose a sentence which is as harsh as this, the test of evidence has to be very, very strong to bring about such a sentence. Number two, a smallest of error, as you said, whether it's the investigation or the nature of evidence that is before the judge, if it leaves even the slightest doubt in the mind of a judge, he would rather not sentence than sentence. Now, if you prescribed, let me say, a sentence of just life or for death and did not, and we found that Justice Lokur will agree that in cases where there was a mandatory sentencing, if found guilty, even in economic offenses, which had minimum sentence of 6 months or 10 months, and the judge had no power to reduce that particular sentence. Again, there will be a hesitation on part of the judge, because if he found that the circumstances were extenuating or they were doubtful, if they were doubtful, there will be a hesitancy to bring about any kind of a conviction there. So therefore, the harsher the sentence, the lower, as we had also debated earlier, will be the rate of convictions.
Right. Just a reminder for our subscribers here, please don't hesitate to send in your questions. We have some very intelligent questions coming in. We've already spoken about the crimes for which and the sort of cases in which we've seen death penalty being awarded. Now we have a question coming in from Anirudh Punakar, who's a subscriber. He's asking, has there been an audit on the type of demographic and social status of the criminals who are awarded the death penalty? He says that it seems that mostly it is the poor and marginalized who are awarded this. We don't see anyone from the upper strata who is awarded the death penalty. In addition to that, may I please also add for all of you, as an educational exercise, to also tell our viewers why is the demographic and the social status of these criminals important when we talk about award of death penalty and about the sort of legal aid that they usually have access to. So if you guys could please comment on that.
Yeah.
I think, Anup, you people have done the maximum work on this, and this is questioned right in your...
Yeah. So, look, we sort of interviewed all of India's death row prisoners and their families and brought out exactly the question that Anirudh is asking. In terms of who gets the death penalty in India. And as Anirudh rightly guessed, and we were able to confirm Anirudh's intuition with actual data that it is the most poor and the marginalized that get the death penalty in India, right? And you're not going to find a rich person on death row, right? And it's an intersection of many vulnerabilities. It's your social position, your educational levels, your income levels, right? It's a mixture of many vulnerabilities, and you need to ask yourself, and what we're finding for the death penalty here in India is true of all retentionist jurisdictions across the world, in terms of all countries that retain the death penalty and use the death penalty. So India is not some exception in terms of saying that it's only the poor that get the death penalty. Across the world, across time, that has been the reality. And to answer your question, Apurva, in terms of why that is so important, I think Meenakshi ma'am and Justice Lokur will tell you, in terms of cases they've seen on then the death sentence cases that they have had, the kind of abysmal representation that these people get in the courts below, right? And this is not a legal aid versus non-legal aid question, right? Our data shows quite counterintuitively that in the trial courts, most of the people who get on death row are actually, they do have private lawyers, about 60 to 65%. But when they go to the high courts and the Supreme Court, that is completely inverted, because they're now exhausted all the meager resources that they have. And it's a truth that it's very poor people who are trying to hire private lawyers at the trial court. And you'd ask why. There is a deep suspicion of the legal aid system, right? And therefore people take on debt, they borrow money, they sell whatever little things that they have in the effort to hire a private lawyer. But even in hiring that private lawyer, they get a terrible private lawyer, right? So the point I'm trying to make is that the quality of legal representation, irrespective of whether it is legal aid or not legal aid, is very poor when it comes to death sentence case. I think it was Justice Lokur who said that legal aid for the poor should not mean poor legal aid. Did I get that right, sir? Did I attribute it right to you?
Yeah.
Right? Yeah. Right. And that's exactly what happens. The poor get poor legal aid. I mean, irrespective of just legal aid. When I say legal aid, I mean legal representation, right? The poor get poor legal representation. Even if I'm having a private lawyer and I'm paying that person 500 rupees per appearance, when that person is actually looking to get paid 2,000 rupees per appearance, he or she is only going to invest that kind of effort and time in my case, right? And all of these cases, the statistics over 2 decades that I indicated at the beginning, shows that if you had a half-decent lawyer, right, there is no business for you to even get onto death row, right? And the manner in which the law that the Supreme Court has laid down is flouted both by incompetent representation and very poor adjudication, results in this rather tragic situation where people spend years and years on death row before anything can be done about it. Yeah.
Justice Lokur, Meenakshi ma'am, what has your observation been by interacting with people on death row?
Yeah, I think it's a little paradoxical kind of situation. As Anup says, that at the trial court level, a person, an accused person, hires a private lawyer, right? Spends all his money, okay, and ends up getting convicted and ends up getting, the death sentence. Okay. Now, he doesn't have the money to go to the High Court, but the law requires that the High Court has to confirm the death sentence. More often than not, at the High Court level, and I think perhaps in most of the cases at the Supreme Court level, it is a legal aid lawyer who represents the person on death row, right? So, but as Anup says, the acquittal rate. Forget about reducing the commuting the death sentence to life imprisonment. The acquittal rate is very high. Okay, so at the trial court level, you have private lawyers who are unable to, get an acquittal for their client, but end up getting, a conviction and death sentence. But at the High Court level or at the Supreme Court level, you have legal aid lawyers who are not taking any money from this person, and they're able to get an acquittal. So it's a bit of a paradox, I'm unable to understand that. Perhaps, the quality of the lawyer makes a difference, I don't know. Or the commitment that the lawyer has, at the level of the High Court and at the level of the Supreme Court, the lawyers are definitely committed. I would assume they are committed at the trial court level as well. But I'm unable to understand, or explain this paradox.
Or is just the quality of adjudication, right? Yeah.
It's possible it's the quality of adjudication.
Well, we will be coming to the quality of adjudication per se. We have questions. Do you want to add something?
Yes, I wanted to add something. And this is what Justice Lokur just said, having been on the other side, Judge. There are two ways that I look at what happens at the level, let me say at least at the Supreme Court level. You have a legal aid system at the Supreme Court. So there are a lot of jail petitions that come in there. Now, there is a markedly different treatment by the court of a 302 death sentence row petitioner as compared to a life imprisonment. Life imprisonment is very hard to get through with the court there, because what happens is half the time the material that you get on the basis of which the legal aid lawyers actually prepare the petition, although we have some very committed lawyers out there, is completely insufficient. There are translations, there are hundreds of other things, the records do not come fully. So some people who are committed still go there with whatever material they have and they try to push, but life imprisonments are difficult to handle. Because where there is a death row, the courts are also a little bit more conscious. Now that's where they call for the material, and the participation of both the court as well as that of the lawyers is at that level of the High Court and the Supreme Court is actually much more proactive. Yeah. But I do believe where we are incarcerating a person for life, he too deserves a similar kind of a treatment, because it's not a matter of few years, it's a matter of life sentence, and it's a very long term. The only one more thing that I would like to add, Anup absolutely said correctly that majority of those who get into a death row are actually from economically vulnerable section, because they do not have the wherewithal to get the right kind of a legal advice, assistance at that particular levels. And very often they may be the only earning members in their family. So once they get incarcerated, there is really no money at all outside to enable them to pursue any remedy. But also there is a data that comes from Project 39A, which shows that many of these prisoners incidentally happen to be also first-time offenders. Now, if they are first-time offenders, I would fail there to understand, and we need to devise a system that there's always a room for reformation there for a first-time offender. And therefore, why a death sentence there? However gruesome an offense may be, that's a crime. But one has to see also from the perspective of a criminal. And I think that's where the system has to now move on to look at the whole offense also, at least for the sentencing. I'm not talking about the conviction, but the sentencing from the perspective of a criminal there.
Right.
His background, his education, his family background, mental health, etc., and many other things. And reformation. The reformation theory, I think, needs to be considered much more proactively.
Actually, I'd like all of you to maybe, for our viewers, explain in brief what factors do trial courts have to consider while awarding the death penalty. But before that, because we have a subscriber question coming in, which is similar to the lines of the discussion that we just had on legal representation, Basudev is asking how to better this representation, which is the root cause for conviction. Also, the lawyers who take up these cases are often looked down, is what he says. But if we could, if you guys have any idea on how can we ensure better representation in such cases?
Okay, can I come in on that?
Absolutely.
When I was in the Delhi High Court and in charge of legal aid, right, I knew that, legal aid lawyers were not doing particularly well. And a lot of, persons were not able to get bail or were not able to get an acquittal or a reduction in their sentence. So I requested 2 judges and a lawyer, or maybe 2 lawyers and a judge, I don't remember now, to interview persons who wanted to work on the legal aid panel. Right. So we got a large number of persons who said, we want to be legal aid lawyers. And these three persons, the judges and the lawyer, they interviewed all of them, right? And they came out with a list of about 30 or 40, whatever the number was, and said that, we think that these persons should be on the legal aid panel. So I put them on the legal aid panel and gave them a pep talk, one day called all of them, gave them a pep talk, and then they started doing the cases. And after about a month, that time we had 2 division benches dealing with criminal appeals. So I asked the 4 judges individually whether there was any improvement in the quality of legal representation for the persons who were in jail or who were convicted of an offense. And they said, yes, there is a marked difference, right? And they said that, this has made a huge difference. And now we're getting good quality assistance. All right. And they said that this system should continue. And I'm glad to say that, as far as I know, this system continues in the Delhi High Court. Now, when I went to the Supreme Court, I did the same thing. I requested some judges and again some lawyers to sit on a sort of an interview board and select lawyers. And 40 of them were selected. And I can tell you, from whatever I heard from the judges, they were doing a very good job. And in fact, 20 of them were so committed that I had requested Anup through the National Law University in Delhi to carry out some kind of an audit of the functioning of the Supreme Court Legal Services Committee. Right? We identified some 300 or 400 cases, and these 20 lawyers did those cases, with their heart in it. So I think the selection of lawyers or the method of selection can certainly make a difference. I know it did in Delhi High Court, and I know that it did in the Supreme Court.
Mm-hmm. Okay, that's important. That's actually very good to know. I'm sure our subscribers would be happy to know that. Our viewers would be happy to know that. Do either of you have to add and want to add anything to that?
Yeah, I think Delhi is especially the Delhi High Court and the Delhi District Courts are are miles ahead in terms of the quality of legal aid that is on offer, right? But what is happening in other parts of the country are almost diametrically opposite to what is happening here, right? And in that sense, and of course, Justice Lokur and also Meenakshi ma'am through her involvement in the National Legal Service Authority understand the very serious structural challenges in ensuring any meaningful access to justice in this country, right? And there are very serious structural problems that create this thing that people don't have access or meaningful access to legal representation anywhere near what should be acceptable constitutional standards, right? There is a problem with the law, right? There is a problem with our law in terms of what is identified as sort of a sufficient level of legal representation. And I think there's a need to rethink that itself. But apart from that, at a policy level, the kind of difficulties that legal aid lawyers face, now there is some amount of change in the structure, whether that is working, not working. I think Meenakshi ma'am can throw more light on it. But from what one is hearing, it faces the same kind of problems because different states and different even districts within states are facing a very different reality on what they call now the Legal Aid Defense Council system. Right? Office space, salaries on time, to run a proper legal practice. Fundamentally, the question is this, Apurva, right? Is the state, and that's an important constitutional question to address at some point, is the state equally investing in prosecution services as it is investing in defense services, right? And that question has to be asked. The state cannot, I would think it's difficult to justify for the state as to why it invests more in prosecution services as opposed to, let's say, and how it is investing in criminal defense, right? So I'll just leave it at that for now.
So I have a very, very small comment, and then I call us there. Sir, when we make a selection of people at the level of Supreme Court, High Court, etc., we would ordinarily pick up people who are not only talented, but also have the wherewithal to carry on their practice. And just because there is that fire to do the right thing, very often you get the talent. And that's what happens at the level of High Court, Supreme Court. But the legal aid services, which go down to the trial court level, what happens is people come on it for the purpose of even making their living. Now, there it is not necessary because the rates are small. The payment is small from the legal aid thing at the trial court level. The amount of time that is required to be invested in these particular matters, the talent that it should attract to carry out this work is not necessarily there. And that is why we tend to probably lose out much more at a trial court level in terms of a quality legal assistance to people who are inside the prison and do not have the wherewithal to maybe engage lawyers who would render that service. So I think there is something that is required to be done. I cannot put my finger on it. Maybe Anup will be a better person or you will be a person, but there is this marked difference because we see the youngsters at the High Court and the Supreme Court, they are driven. And they are talented. And perhaps when they do legal aid, they don't look at legal aid as something to make money, but it's a zeal to do something that is right. But that's not necessarily so at the trial levels here.
Right. Vasudev, you've definitely given something for all of us and our viewers to think about. So thank you for that question and thank you for your responses. Ma'am, we have a question coming in specifically for you. This is an anonymous attendee who says, Ms. Arora raised an important point about reformation rather than punishment. And I'm glad that our audience is engaging very positively with the points that are being put forth by the panelists. Now he's asking, or they are asking actually, how can we make this possible?
I think the Supreme Court in its judgments, I'm sure Justice Lokur will have much more to say on that than I will. But I think Supreme Court has already now on the aspect that, see, death sentence has a finality to it. And that finality is irreversible. So once you sentence a person to death, you leave no room for any reformation. Number one. Number two, how so heinous the crime may be, it is not that human beings are not beyond redemption. So therefore, now the present guidelines that have come from Supreme Court actually focus more on the reformation. They have asked that there should be an psychological evaluation of an accused at the time when an offense is committed, to see what the mindset is. And then when the trial is on and before the sentencing comes in, and he's been in prison for some time, have yet another one before the sentencing is carried out. Now, while the accused is in prison, and you have these 2 points, and the trials in India are not necessarily very quick and they get over in a small period of time. They do take their time. If you would notice that a person has a room for reformation, then death sentence should not be an option at all. Should not be an option at all. And I think that's a very good direction there. Apart from that, the court has come out with various factors and materials now to be placed before the court before a sentence is pronounced. And I think Anup will...
we want to speak of that. So if one of you could briefly, we just have 15 to 20 more minutes. Please, could elaborate just as an educational exercise, just to elaborate on the factors that the courts need to consider and the factors that they are in fact considering.
Okay, I'll just put on my teacher hat on and try and explain this as quickly and as simply as possible, right? So obviously we're talking of sentencing, right? So at this stage, by the time you come to a sentencing stage in a legal process, in a trial, let's say, you've already found the person guilty of the crime. So we are not in the realm of is a person guilty or not. The person is guilty. Now we're trying to determine what punishment, right? Now the courts have, after I think a bit too late, but still great over the years that this has been a moment that has been in the making. They're saying, now how do I decide as a judge that I should give you, whether I should give you the life imprisonment or the death penalty? Our law is default punishment is life imprisonment. You have to show special circumstances if you want to give the death penalty, right? Now, how should a judge decide this? And there are two things. One is backward-looking factors, right? In terms of a person's life history, how they grew up, their childhood, their environment, there's their mental health status, right? And a whole range of environmental life factors in going into determining who this person is and how those factors impacted your decision-making process to either commit the crime or whatever else, right? So there is that. In that sense, it's backward-looking. It is looking at things in your life before you committed the crime and the sort of influence they might have had on you as a person and how it interacts with you, how your life factors interacts with you as a person towards the decision-making process too. In terms of and that's what courts call a culpability analysis, right? Or culpability assessment. How culpable are you given all the things that has happened in your life? That is one thing. The second thing is what Meenakshi ma'am was talking about, which is forward-looking, right? Which is that the state has to show that if I want to take this person's life, that this person is incapable of reformation, right? And unfortunately, which might seem a very simple formulation, which the courts first said in 1980 when they were upholding the constitutional validity of the death penalty, a rather simple formulation which says that, yeah, if as the state you want to take this person's life, you show us that this person is incapable of reformation. But the manner in which this has been flouted at all levels of the judiciary, including the Supreme Court, is mind-boggling, right? How little discussion there is in determining whether an individual is incapable of reformation. The burden is on the state to show that because it is a state that wants to take somebody's life. So if you want to take somebody's life, the burden is on you to show that that person who you want to kill is incapable of reformation, right? And the structural reality is, as much as systemically we are committed to reformation, our prisons are very, very far from being meaningful institutions of reformation. So I'll just stop there. But the difficulty has been that this is all what the law is saying, and the Supreme Court is clarifying over the years, but you just have to see how little of this is actually followed in the trial courts or the high courts, right? And that is the fundamental problem with the administration of the death penalty in India, that it is fundamentally unfair and arbitrary. Yeah.
We will come to adjudication like I had promised. Before that, Justice Lokur, would you like to add anything on reformation?
It's of course, there is no question about the fact that, the courts must look at the possibility of the person being reformed. But how do you look at it? Now, for example, in the Juvenile Justice Act, all right, child offenders. The purpose of the Juvenile Justice Act is to reform the child, rehabilitate the child, reintegrate the child into society. Okay. Nobody has an idea how to do it. What are the considerations that go into it? You can talk about a child care plan, okay, but what kind of a child care plan? What should it consist of? Now, the same thing, is at the level of an adult. You say that, yes, I want to reform this person, or I think he can be rehabilitated. On what basis do you come to that conclusion? How do you come to that conclusion? All right. So these are very difficult issues, and you have written, Apurva, about these some 26 cases which you have analyzed. All right, where the judgment of the Supreme Court regarding reformation, mental health, and all those issues, psychological analysis and all that. In 24 cases, they've not even referred to the Supreme Court judgment. So I don't know what the reason is, but certainly one solution to that is to have, some more meaningful judicial education. Okay, judges need to be educated on this.
Right.
Because they're the ones who are giving the death sentence. Lawyers need to be educated on this. That you are the prosecutor, you want to take somebody's life. Why do you want to take somebody's life? Is it because you think he is beyond the Reformation? Okay, how do you come to the conclusion that he can't be reformed? Defense lawyer also, because the defense lawyer is trying to save that person.
Right.
So I think everybody, whether they're judges, prosecutors, or defense lawyers, they need to get together. And there has to be this, education passed on to them, because you've got so many judgments, starting from Bachchan Singh.
Mm-hmm.
They're saying the same thing, maybe in some different words, different language. But where are we? We're still where we are, where we were in 1980.
Right.
Can I just add to that? Justice Lokur will agree that we lost our way somewhere after Bachchan Singh with Ramji.
Yeah.
And we seriously lost our way. And the Supreme Court has noticed in its judgment in that Bariyar that there have been death sentences that have been awarded on incorrect principles, application of incorrect principles, where only the offense or the crime was judged and not the criminal himself or herself. So I do feel that's a very, very serious thing, and there is no room for any error in this area. There's just no room for any error. The finality is far too much.
Apurva, if I may just frame this, I think the question we really need to ask ourselves is that, look, all of us might have different views morally, politically, philosophically on is the death penalty legitimate or not, right? We can have a different view that it's violative of dignity. Some might say it's not violative as an idea, as a concept, as a punishment. We can have that position, right? But I think the first question we need to urgently answer is, does India have a criminal justice system? Given the multiple facets of a criminal justice system, does it have a criminal justice system that can, in any sense, fairly administer this punishment, right? And for me, the answer is a resounding no, right? That our criminal justice system cannot be entrusted with such a punishment, right? It gets it wrong far too often. There are very structural problems with our criminal justice system that we are not going to fix. And the price we are paying for that is asking people to suffer this punishment, right? And you and I sitting away from the death barracks of the prisons in this country, for us, it's an abstract concept. It is a conceptual discussion. Oh, should we have the death penalty or not? But we really struggle to understand what is the day-to-day suffering of living on death row, right? And I think, we are able to get this distance and therefore debate it as an issue without really imagining it as a torturous human experience living on this punishment day to day.
No, that's a very important point.
Can I just add one more sentence?
Absolutely.
I would like to go beyond the courts. Okay, so when a person is convicted and the death sentence is upheld, he makes a mercy petition. How does the government look into it? Do they look into issues of reformation? Do they look into the backward looking? Do they have that forward looking? So the process should not stop only at the court level.
Right.
It should go beyond that, because there's a mercy petition. The matter goes to the president. The president has to exercise his or her discretion. What is the material before that person to come to that conclusion? Right. So let's go a step further, beyond the courts also when we are discussing this.
Absolutely, all valid questions, and we will get to adjudication. Just a reminder, we've almost reached the end of this webinar, this discussion. Big thank you to all our subscribers again, and the article that Justice Lokur was referring to, I will be adding a link to that article in the description if any of you are interested in reading it. Just one final question, because I promised I would be taking something up on adjudication, and that's something that we haven't touched upon fully in this discussion. I have a question coming in from Sanjeev Galvankar. He's a subscriber. He's asking, conceding that the interpretation of facts surrounding the crime and also accepting that it is not possible to insulate the judges from societal pressures, is it possible to set parameters or parameterize in cold logic the rarest of the rare cases whilst awarding the capital punishment?
No.
That's the long and short of the answer.
I think that's you.
No, look. There is a push and pull factor here, right? Punishment has to be individualized, right? It has to take into account individual factors, and at the same time, you're also interested in a certain amount of consistency, right? And how you treat these factors are factors coming in for all kinds of accused, irrespective of whether you're rich or poor. So we want that consistency in treatment, but we also want that individualized treatment, and they pull in opposite directions. And both of these are commitments of the law, right? And that is a struggle, right? And I think it was Justice Blackmun in the Supreme Court of the United States who started his career on the bench of the US Supreme Court saying that, yes, the death penalty can be reformed. The administration can be reformed. And for about 3 decades he was on the US Supreme Court, he tried various permutations and combinations to make this administration fairer, to come up with the kind of guidelines that you're asking us about. But towards the very end of his tenure on the US Supreme Court, his final word of judgment on this was that from this day onwards, I shall no longer tinker with the machinery of death, right? Right? That it is impossible, that the kind of thing that you're doing and the kind of punishment you're talking about, it is impossible to go down this reformist path. You will not achieve it. But I guess people like me who work on this issue also understand that we will not get to abolition of the death penalty until we go past this reformist phase. And we have to engage with the courts in their attempts to reform. And ultimately, they will see that these reformist measures will not work, right? But we have to necessarily go through that phase of trying to reform the death penalty before we get to abolishing it. Yeah.
Ma'am, Justice Lokur, would you guys like to add anything to that?
Yeah, I agree with Anup. You can't have a straitjacket formula, that it's this death penalty, but it's not this, no death penalty. The variety of factors, including the makeup of the judge. We talk about the makeup of the criminal. What about the makeup of the judges? That's also a factor.
Yes. So the classic example, as Justice Lokur said, comes from Bachchan Singh, which said the crime and the criminal are two separate, distinct things.
Right.
And then when we came with Ravji subsequently, we said it's only the heinousness or the depravity of the crime, and do not look at the criminal. So we have now brought that facet of criminal back. So as you said, the judge becomes a very important factor. What is his mindset and how he looks at an offense or he looks at the criminal. And somewhere there, Justice Lokur, I will completely agree with you that it's not just the education for the judge and the bar, but for the judge, it's not just the law, but also the ability to look at a criminal as another human being with diverse backgrounds and everything, a compassionate sense there to look at the offense.
Right. With that, we've reached the end of this edition of the Print Charcha. A big thank you to all our panelists for joining us, for answering all our subscribers' questions, and for our subscribers for the questions that you sent in, for engaging with our panelists. Once again, before we end, just to thank our subscribers for always supporting us and for supporting our journalism. It's only and only because of you guys, all of you, that we're able to carry on with our unhyphenated journalism. So a big thank you to all of you.